Kelly Vaughn is there in Rexburg. Of course, she's been there for the last couple of days following the story, and we'll have a complete team update for you tonight coming up on 2 News at 4, 5, and 6. But Lori Vallow present right now in court with her attorneys after being extradited from Kauai. She took a flight to Boise. She was seen at LAX airport. That was her first stop. She was under guard. She had plain clothes. All right, let's listen in. The judge has entered and is starting to talk now. Let's listen in.
Ms. Daybell, it's my understanding that you've hired these 3 attorneys that are with you here today, and that's your position that you'd like to retain your own private counsel. Is that correct?
Yes.
Did you get a copy of the criminal complaint as well as the arrest warrant that has been issued in this matter?
Yes.
Ms. Daybell, I can read the criminal complaint in its entirety, or we can summarize it going through each of the charges. Which would you prefer?
We will waive a formal reading, Your Honor.
Okay. We'll just go through the counts then, one by one, as well as the penalties. This criminal complaint was filed here in Madison County on February 18th, 2020. It is State of Idaho versus Lori Noreen Vallow, aka Lori Noreen Daybell. It charges the defendant with 5 different counts. The first count is desertion and non-support of children or spouse. That count is a felony under Idaho law, Idaho Code 18-401, Section 1. The punishment is up to a 4-year maximum imprisonment in the state penitentiary and or up to a $500 fine. It designates or alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or between the 23rd of September 2019 and the 18th day of February 2020 in the county of Madison, state of Idaho, did desert a child under the age of 18, to wit, JV, date of birth 5/25/12, who was dependent upon the defendant for care, education, or support with the intent to abandon JV. Ms. Daybell, do you understand what count 1 alleges, as well as the maximum penalties?
Yes.
Under count 2, it is that same charge, desertion and non-support of children or spouse. It's also a felony under Idaho Code 18-401, subsection 1. It is punishable by up to 14 years in the state penitentiary and or up to a $500 fine. It alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or between the 8th day of September 2019 and the 18th day of February 2020 in the county of Madison, state of Idaho, did desert a child under the age of 18, to wit, TR, with a date of birth of 9/24/2002, who was dependent on the defendant for care, education, or support with the intent to abandon TR. Ms. Daybell, do you understand what's been charged in count 2 as well as the maximum penalties?
Yes.
Ms. Daybell, count 3 is a misdemeanor under Idaho law. It's the charge of resisting and or obstructing an officer, a violation of Idaho Code 18-705. It's punishable by up to 1 year in the county jail and up to a $1,000 fine. It alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or about the 26th day of November 2019 in the county of Madison, state of Idaho, did willfully delay and or obstruct a public officer, to wit, Lieutenant Ron Ball of the Rexburg Police Department, in the discharge of his office by giving false information regarding the whereabouts of a child, JV, date of birth 5/25/2012, and thereby delaying the search for JV. Ms. Daybell, do you understand the charge in count 3 as well as the maximum penalties?
Yes, I understand the charge.
Count 4 is also a misdemeanor. It's a charge of solicitation. It carries with it up to 6 months in the county jail and a $500 fine. It's a violation of Idaho Code 18-2001. It alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or about the 26th day of November 2019 in the county of Madison, state of Idaho, with the purpose of promoting or facilitating the commission of a crime, encouraged and or requested Melanie Gibb to engage in conduct which would constitute the crime of resisting and or obstructing an officer by requesting and or encouraging Melanie Gibb to give false information to law enforcement regarding the whereabouts of a child, JV, date of birth 5/25/2012. Ms. Daybell, do you understand the charge of count 4 as well as the maximum penalty?
Yes.
The last count is count 5. It's a misdemeanor under Idaho law. It's a charge of contempt, a violation of Idaho Code 18-1801, subsection 4. It's punishable by up to 6 months in the county jail and up to a $1,000 fine. It alleges that the defendant, Noreen Vallow, aka Noreen Daybell, on or about the 30th day of January 2020, in the county of Madison, state of Idaho, did willfully disobey a lawful court order in Madison County, case number CV 3320-45, by failing to physically produce minor children JV and TR to the Rexburg Police Department and or Idaho Department of Health and Welfare within 5 days of service of the order. Ms. Daybell, do you understand what's been alleged in count 5 as well as the maximum penalty?
I understand.
Ms. Daybell, do you understand that all of those charges and their maximum penalties could run consecutively, one after the other, or they could run concurrently, meaning at the same time? Do you understand that?
Yes.
In addition to the rights form that you've already filled out, pursuant to Idaho Criminal Rule 5, I'm also going to give you the following rights. Number 1, you are not required to make a statement, and that any statement made by you today can be used against you in court. Number 2, you're entitled to know the nature of the charges that have been brought against you, which we've already gone through. Number 3, you are entitled to bail. You have a right to bail. Number 4, you have the right to be represented by counsel. Number 5, you have a right to a preliminary hearing. That preliminary hearing must be set within 14 days if you're incarcerated. It can be set within 21 days if you're not incarcerated. That preliminary hearing is a probable cause hearing where the state will have the burden of showing probable cause that the 2 felonies have been committed in order for you to be bound over to the district court. You also have the right to communicate with counsel and immediate family, and that reasonable means will be provided for you to do so. Do you understand those legal rights, Ms. Daybell? All right, Ms. Daybell, now we'll schedule the preliminary hearing. I've met with counsel in chambers prior to coming out here, and there's a few dates that I believe did work. Mr. Wood, on behalf of the state, you designated that the state needs approximately 2 weeks to be ready. Is that correct?
Yes, Your Honor.
And you also designated that the state needed 2 days for the preliminary hearing to take place. Is that correct?
Yes.
Does the defense want to comment as far as how much time they need to be ready, as well as how much time the preliminary hearing will take?
Your Honor, I think 2 weeks is more than sufficient, and I agree with the proposed 2-day setting.
Okay. All right. The court has available March 18th and 19th. Does that work for counsel for the defense?
We'll make it work, Your Honor.
Does, Your Honor. Your Honor, the state may have an issue getting one of our witnesses over here from Hawaii on the 18th. We had asked previously that it be set for the 19th and 20th and would continue that request.
Mr. Wood, if you made some arrangements so that if your witness could only be here by the 19th, that we allowed that witness to testify on the 19th, would that appease your concern?
Yes, Your Honor.
Does the defense have any objection to that, to moving things around a little bit so that that witness can testify on the 19th and not on the 18th?
No, Your Honor.
All right. We'll schedule then the preliminary hearing for March 18th and 19th here at the Madison County Courthouse. We'll schedule that right at 9 a.m. The court notes that there was a motion for a bond reduction that was filed by the defense in this matter approximately 2 days ago. Has the prosecution received a copy of that motion to reduce bond?
Yes, Your Honor.
Mr. Wood, is the prosecution objecting to that being heard here today?
No, you're not. No, we're not, Your Honor.
All right. We'll hear the motion to reduce bond then today. Ms. Elcox, are you going to be arguing that?
Yes, Your Honor.
You may proceed with your argument. I want you to know that I have reviewed your motion. I've also reviewed Title 19, Chapter 29, and Idaho Criminal Rule 46.
Thank you, Your Honor. Your Honor, we are asking that the court today set bail in the amount of $10,000 consistent with what Lori's attorney in Hawaii requested. In the event that the court is not inclined to set bond in the amount of $10,000, we are asking that the court consider setting a bond no higher than $50,000 in this case. Lori is presumed innocent as she stands before the court today. The fact that she is presumed innocent is not a loose guideline. It's a foundational principle of the American criminal justice system. Under both the 8th Amendment to the United States Constitution and Article 1, Section 6 of the Idaho Constitution, excessive bail is prohibited. Judge, you are the gatekeeper in this case. You're the guardian of the presumption of innocence and the constitutional rights afforded to Lori. This is not a court of public opinion. This is a court of law. And are we going to let our citizens' rights be dictated by what appears in the media? Bail must be set in an amount that assures Lori's appearance in court and is commensurate with the charges that she is actually facing today in court. A $5 million bond is unreasonable, it's astronomically excessive, and is the functional equivalent of holding Lori without bond. This is a violation of Lori's constitutional rights. I can tell the court that in my almost decade of practicing law as both a prosecutor and a defense attorney, I have never seen the crime of desertion charged. This is because abandonment issues are generally dealt with under the Child Protection Act, not the criminal code. But even under the desertion criminal statute, which Lori has been charged with and faces these charges here today, the maximum fine, as Your Honor said today in court, that can be ordered is $500. Yet her her bail is set at $5 million, 10,000 times the maximum fine in this case. In a recent Madison County murder case, the bond was set at $1 million. In the 5 counts the court read today, charged in the criminal case, there is not one allegation of a crime of violence. A bond set this high denies Lori due process and fundamentally deprives her of her ability to meaningfully participate in the defense of these allegations she faces. It is clear that the government just needed to find a charge that would fit in this case because of all of the media attention surrounding this matter. The last thing that should happen is to allow this case to be tried in the media and to allow public opinion and rampant speculation to dictate how this case proceeds through the judicial system. Considering the purpose of bail, to which Lori is entitled as a matter of right, Idaho Criminal Rule 46, as Your Honor referenced, lists the factors that the court should consider when determining the appropriate bail amount to set in this case. Pursuant to those factors, Lori's bond should simply be reduced in the amount requested because she has no criminal history whatsoever. In fact, Lori took the initiative while she was in Hawaii to contact law enforcement and say, in the event that a warrant issues, she will voluntarily turn herself in. Police did not afford her that opportunity to do so. They created a spectacle out of the situation when they knew that Lori had contacted law enforcement and indicated that she would turn herself in. She waived extradition in this case. She did not fight returning to Idaho. She has hired 3 criminal defense attorneys from 2 different law firms, and she is dedicated to vigorously defending against these allegations. We, as her attorneys, also agree to assure Lori's presence in court. Chad, Lori's husband, has returned to Idaho to his home of his own volition, and Lori and Chad maintain a residence locally. That home was purchased over 5 years ago, or approximately 5 years ago. Chad, their children, their children's spouses, and their grandchildren are all located locally. Furthermore, Lori's passport is expired. She has no flight risk whatsoever, and this assertion that when this investigation began, when there was initial law enforcement